Today we're covering bonds. Previously we covered liens. There are important differences that you need to know, steps that you need to take to protect yourself to ensure that you get paid. So bonds can be broken down into three categories: private project bonds, state or public bonds, and federal projects. I'll get us kicked off with the private project bonds, which are governed by Florida statute. They're found in Chapter 713, which happens to also be the Florida construction lien law. Then my partner Ryan will cover the state and public project bonds, which are governed by a different statute, and that's Section 25505 of Florida statutes. And then finally, Joby will cover the federal project bonds, which are governed by the Miller Act. So if you were not aware, and it's not only private or federal projects where a bond can be in place. Private projects can also have a bond. A private owner, not just a government, can have a bond provided for that project. And so why would a private owner for a private project want a bond? Well, the bond exempts the owner's property from liens. Protects the title of their property, protects their property from being foreclosed on. It also protects the owner against high-risk prime contractors. And I find that an owner may be wise to have a bond or bonds put in place where there's a relatively smaller contractor taking on a much larger project where cash flow and downstream payment could become an issue. It is the general contractor who furnishes the bond to protect the owner. That bond also, the payment bond also protects the subcontractors and suppliers. Cost benefit of the bonds, the owner ultimately pays for it. The general contractor rolls the cost of the bond premium into the cost of the work. So it doesn't cost the general contractor anymore to get a payment bond in place to protect the interest of the subcontractors and suppliers. We'll talk mostly today about payment bonds that protect your interest as a sub or supplier to get paid. But I want to point out that there is a distinction between a payment bond and a performance bond. They are two different bonds, two different types of bonds, but they're often spoken about together. You often hear the term performance and payment bonds. But just to be clear, those are two separate bonds with two separate purposes and different rules governing each. The purpose of a performance bond, it protects against failure of performance of the contract. So if the contractor fails to perform, is taking too long, is delayed, is working improperly, or abandons the project, the owner can make a claim on the bond, and the surety steps in and becomes liable for performance. The language of the performance bond is critical. I point that out because most payment bonds are governed strictly by statutory language and not the language within the bond. So within performance bonds, you need to be extra diligent to read the language of the bond to ensure that you comply with it. The language of the bond may incorporate coverage and procedures prescribed by statute. But again, you'll determine that by reading the performance bond. Statutory payment bonds for private projects are provided for by section 713.23 of the Florida statutes, which it's somewhat buried in the construction lien law chapter 713. But it's a relatively straightforward section. If you should become familiar with the entire section 713.23, and you'll find within that section the forms that you need to use to preserve and preserve your rights and to make claim on the bond. They're somewhat similar to the construction lien procedures, but there are some important differences, and we'll point those out today. The claimants who can make a claim on the bond are similar to those that can make a construction lien. On the next slide, we have a diagram that explains who can and cannot make a bond claim. A copy of the bond must be attached to the recorded notice of commencement. That's generally where you as a sub or supplier will go to find the bond and determine whether a bond is in place or not. The law also requires the bond to be posted conspicuously on the property, but I, in practice, have found that is rarely done. But importantly, you as a sub or supplier do have the right to request a copy of the bond. That would happen if you suspect that there could be a bond in place, or you've heard that there's a bond, but it's not attached to the notice of commencement. So here's the diagram of who has bond rights. Just as with construction liens, anyone in direct privity with the contractor, a sub, a material man to a sub, all have bond rights. Those that do not are subs, and material men to material men. This, and to be clear, this diagram of who has bond rights may be different than when you are dealing with a Miller Act or a federal bond. There's a concept in the law called a common law bond as opposed to a statutory bond. And so what does that mean? Well, it's a bond that either tries to but does not comply with the requirements of the statute 713.23. For instance, if it adds additional limitations of who bond claimants, who it protects, who the bond claimants can be, or it changes the notice and timing requirements. Also of note to you, any bond that you give as a subcontractor will be considered a common law bond, not a statutory bond. The common law bond is importantly not governed by the requirements of the statute. It's governed solely by the language of the bond. So it's important to first identify whether the bond is a statutory bond or a common law bond. And then if it is a common law bond, you strictly comply with the requirements of that bond and find out what protections it gives to you within the language of the bond itself, as opposed to the statute. Preserving your bond rights, similarly to preserving your construction lien rights on a project where there is no bond, First starts with the notice to owner. If you are in direct privity with the contractor, it doesn't apply. But if you're a sub or a supplier to a sub, you must give notice to owner, notice to contractor. That notice form is slightly different than the notice to owner used on construction lien projects. The form that you'll need to use is found in section 713.23. It's a relatively simple form, and you can find it in the statute, and that's what you want to use. When do you have to give notice? Similarly as with the lien law, it's before beginning work or within 45 days after first furnishing. Once you provide any labor, materials, or services. However, if the bond is not attached to the notice of commencement, which it is required to be, but sometimes it doesn't happen, you have within 45 days after the date you're provided a copy. So you started the work at the time the project started, the bond was not attached to the notice of commencement, but during the project you learn that there is a bond. You have 45 days to file your notice to contractor from receiving that copy of the bond. The other step and timing requirement that you need to know about is the notice of non-payment. This takes the place of the claim of lien. With the claim of lien, you have to record it in the public records within 90 days of final furnishing. But when a bond's in place, you do not have to record anything. You merely serve the notice of non-payment to the contractor and the surety. And that's, to be clear, that's 90 days after final furnishing of any new labor, services, or materials. For rental equipment, there's now a clarification in the statute that you have 90 days from the date the rental equipment was on the job and available for use. Recently, actually last year, there were some fairly substantial changes to section 713.23. One of which is that the notice of non-payment now must be made and signed under oath. And the form is provided in the statute. And along with that, the concept of fraudulent notice of non-payment, which is similar to lien law. For a long time there's been this concept with lien law of fraudulent lien, and so now that same concept applies with the notice of non-payment. Here's a copy of the form taken directly out of the statute. The form changed last year, so if you have a form, notice of non-payment, that you've been using for years, you need to scrap that and replace it with the new form. The major differences is that you now have to state any work that is to be performed, that hasn't been performed yet, but that you intend to perform in the future, or materials that you intend to furnish in the future. And you have to state the amount paid on the account and the amount to become due in the future. Once you've timely served your notice of non-payment, your next step to enforce your bond claim is a lawsuit on the bond. Similar to a construction lien, you have 1 year. However, there's a big difference in when that 1 year starts. For a bond lawsuit, it's 1 year from last furnishing of services or materials. Whereas with a claim of lien, you have 1 year from when you recorded that lien, which is typically a longer period of time. Your bond lawsuit must be filed sooner because it must be filed within 1 year of your final furnishing of labor or materials. Last thing I want to talk about is conditional payment bonds. You can think of these as pay if paid bonds. If you find that the bond for the project is a conditional payment bond, you need to be very careful because you may have lien rights in that case as opposed to bond rights, and the procedures for preserving your lien rights and making a claim, recording a claim of lien are different. So if it's better to get an unconditional or a section 713.23 bond. So that's preferable, but you need to be aware that under section 713.245 of Florida statutes, there is this ability for the contractor to provide a conditional payment bond, and in some it's only effective if the owner gets paid if the contractor gets paid by the owner. If the owner doesn't pay the contractor, you as a sub or supplier will not have a claim on the bond. So you may end up with no bond protection. With that, I will turn the mic over to Ryan Maloney to talk about 255.05 bonds.
Good afternoon, everyone. I hope you're enjoying the presentation so far. I'm going to talk about Florida Statute 255.05 bonds, and these are bonds that are required on all Florida state and local government projects over a certain amount. These bonds take the place of construction lien rights because there is no right to lien state or local government property. Sometimes the 255.05 statutory bonds are referred to as Little Miller Act bonds, or this is Florida's Little Miller Act. And the reason for that is because it is based off of the Federal Miller Act, which my partner Joby will address at the end of the presentation. It's similar to the Federal Miller Act, but it has its own nuances. But again, it's required on every project over a certain amount for any state, county, or city in Florida. So like the other payment bonds that Austin was speaking about, 255.05 payment bonds must be recorded in the public records where the project is located. And then this slide details the information that must be included in the 255.05 payment bond. There's actually a statutory form for the bond that's in the Florida Statute 255.05. The information is helpful for you as a claimant because it provides you the information that you need in order to provide the required notices that may be necessary that we're going to talk about as we go a little further into the presentation. In addition to the bond being recorded in the public records such that it's available on a public records search, claimants also have the right under section 255.05(1)(c) to make a formal request for a copy of the bond as well as a copy of the prime contract to the governmental entity, and the governmental entity is required to provide that. So that's one way you can make sure, do you get a copy of the bond, that you have it and you're providing the proper notices that we're going to talk about going forward. So, one slide, yep. So I did talk about certain projects that are state or local government that are less than $100,000. There is no requirement for a 255.05 bond. If the project is, the total value of the project is in excess of 100,000 but less than 200,000, the state or local government has discretion whether to provide a bond or not, and oftentimes they do not. So really, if the project's under 200,000, it's unlikely it's going to have a bond, but I would say that most state and local government construction projects are generally in excess of $200,000 in total value. So you can pretty much feel pretty comfortable that most projects of size are going to have a 255-05 bond to provide potential payment protection for you as a subcontractor or supplier. So this slide talks about who are the protected claimants that could make claims under 255-05 bonds, and they're similar to the claimants that could make claims under the construction lien law. So first tier subcontractors that have contracted directly with the general contractor have rights on the bond. Second tier subcontractors, those that contract directly with the first tier subcontractor. First tier material suppliers, so suppliers to the general contractor have bond rights. And second tier material suppliers, those supplying to a first tier subcontractor or material supplier will have bond rights. Importantly, third tier subcontractors or subcontractors do not have any rights to claim on a 255-05 bond, similar to not having lien rights as well. And then also suppliers to suppliers are not going to have bond rights. But it really goes down two tiers is how you probably want to think about it largely. So there's perfecting the bond right. There are a couple notices that have to be provided for those parties that are not in direct privy with the, don't have a direct contract with the general contractor. So these would be suppliers to subcontractors, subcontractors, anyone that has bond rights but doesn't have a direct contract with the contractor. And both of these notices need to be timely served, or the rights to claim on the 255-05 bond will be lost. The first is the notice to contractor, and the second is the notice of non-payment. So first, the notice to contractor. Again, this is required if you do not have a contract with the general contractor. The notice to contractor, needs to be served on the general contractor within 45 days after you first begin to furnish labor, services, or materials to the project. That time is a hard time deadline. If you miss that deadline, you are very likely to have lost your rights to later claim on the 255-05 bond. The notice must state that the bond claimant intends to look to the payment bond for protection, and the concept is similar to the notice to owner requirement under the lien law. One thing that I think is important, it must be served on the contractor, but I would say good practice is to also serve your notice to contractor on the surety as well, so the surety is aware. Important note on this is you need to serve this notice to contractor timely, even if there's no payment issues at that point in time. This is sort of a protective notice with the idea to make sure that the contractor knows that you're out there as a potential claimant. And so even if you're being paid timely, you still need to make sure you serve this notice, similar again to a notice to owner. And I've seen this can really catch some folks and be sort of an issue that causes problems down the road. So you want to really make sure on state or local government projects that you have this deadline calendar and that you're getting out this notice to contractor as a matter of course. So then the second notice that's required if you don't have a direct contract with the prime contractor is the notice of non-payment, and that only needs to be served if you're not receiving payment. It must be served on the contractor and the surety, so both have to get a copy of the notice of non-payment, and you can't serve it any earlier than 45 days after you first start furnishing labor, services, or material. And very importantly, you cannot serve it any later than 90 days after the date of your final furnishing of labor, services, or materials. So if you serve it on day 92 or day 95, it's too late and you've lost your rights to claim on the 255-05 payment bond. So very important to make sure if you're running into payment issues that you calendar, that you're prepared to make that serve that notice of non-payment, and that you calendar that deadline and serve it well before the 90-day deadline. There's a form in the statute that actually similar to what Austin was talking about, has also been updated last year, and the form now requires that it be a sworn notice of non-payment. That requirement wasn't there before. So like Austin said, for the private bonds, if you have an old notice of non-payment form, you need to look and make sure that that complies with the new statutory form and you're meeting those requirements. So if you serve an old notice of non-payment that's not supposed to be sworn, you may run into an issue where it's considered to be invalid. So you really want to make sure you're complying with the current, as of last year, notice of non-payment form in the statute. And again, one thing that's nice about the 255-05 bonds, unlike in the lien law where things are kind of all through Chapter 713, everything is in this one statute, 255-05. So this form is straight from the statute. Similar to what Austin was talking about, in the statutory changes last year, they also created this concept of a fraudulent notice of non-payment that wasn't in the statute previously. It is similar to the fraudulent lien concept under the lien law, and a notice of non-payment will be considered fraudulent if it's determined to have been willfully exaggerated as to the amount unpaid, or if willfully includes claims for work not performed, or it's prepared with such willful and gross negligence to amount to a willful exaggeration. Importantly, if there's a minor error or miscalculation, or there's a good faith dispute as to the amount that's unpaid, that's not going to constitute a willful exaggeration. It has to be determined to be willful, or just you put it together so sloppily that it amounts to a willful exaggeration. If you do, if your notice of non-payment is ultimately determined to have been fraudulent, that is a complete defense for the surety to the claim on the 255-05 payment bond. So something you want to be careful when you're putting these together, that you can back up the amounts that you're including in your notice of non-payment, and that it ties to your contract. There is a strict deadline for filing a lawsuit on the 255-05 payment bond. Similar to the private bond that Austin was talking about, an action on a 255-05 payment bond has to be filed with the court within 1 year after the final performance of labor or completion of delivery of the materials or supplies to the job. If you file your lawsuit after that 1 year deadline, your lawsuit is going to be invalid and you're not going to have a valid claim on the payment bond. When you file the lawsuit, you have to sue the surety. That's the one party that has to be named in the lawsuit. Typically, you will also name the contractor that issued or that got the bond as well, but you don't have to name the contractor. It's not required, but typically you'll see that as well. But you have to name the surety on the bond. One thing that I see come up a fair amount, and recently came up on a pretty large project that I'm handling for a client, with actually working with Joby down in South Florida, that has a 255-05 payment bond issue, is you may have the contractor or the surety tell you, hey, can we agree to a tolling agreement? Meaning we'll agree in a document to say, hey, you don't have to file your lawsuit within the 1 year deadline. We're going to toll that deadline or extend that deadline by agreement for some period of time, usually to work out maybe some dispute between the owner and the prime contractor. I'm telling you now, don't do that. Do not agree to that. You can accomplish the same thing by timely filing your lawsuit and then agreeing to stay the lawsuit for some period of time while that dispute gets worked out. There's nothing in the 255-05 statute that would allow such a tolling agreement to be enforceable. There are some cases with the Federal Miller Act that you could argue would allow a tolling agreement, but my strong recommendation to anybody listening to this is never agree to a tolling agreement like that with the surety, and just file the lawsuit and get it stayed. And that way You don't have to worry about the deadline. Your lawsuit is filed. You may put it on ice for a while, but it's filed, and you're not going to lose your rights on the bond. Next slide. So finally, when you file, if you get to the point where you have to file your lawsuit on the bond, what can you recover as far as damages? So you can recover for any unpaid labor, materials, or supplies that were provided and incorporated into the work. You can recover your court costs, and very importantly, you can recover your attorney's fees if you're the prevailing party on the bond. And that's the case even if your subcontract or your purchase order doesn't have a prevailing party attorney's fee provision. The Florida Statute 255-05 provides that a prevailing party is entitled to recover their attorney's fees. You can also recover pre-judgment interest. So the interest, either based on your contract, if the contract has an interest provision, or based on the statutory interest rate from the time when the payment was due to when the recovery is made via judgment in the lawsuit. Another important aspect of 255-05 payment bonds is that pay if paid provisions in subcontracts, while they may be a defense to a claim by you against the contractor, for example, they are not a defense that the surety can raise to the payment bond claim. And there's a couple cases on that, but one specifically addressing 255-05 is the Everett Painting Company versus Paul and Wadsworth construction case, and that stands for that proposition that a pay if paid provision is not going to preclude your bond claim under 255-05. You can recover for your base contract work and for changed work, even if there's a dispute about the change order. If you prove that you're entitled to the change order, you can recover for that. But you can't recover for delayed damages. Things like extended general conditions, those type of delay damages, because those are not considered labor, materials, or supplies under Florida Statute 255-05. There is, with respect to retainage on these types of jobs, there's a special provision in 255-05 that relates directly to retainage, and it sets forth certain timing requirements that are in addition to the base contract work, that you can't include a claim for retainage in your bond claim until certain conditions are met, primarily related to the timing of the owner's payment of retainage to the prime contractor, or if that hasn't been paid, the timing of the contractor's request to the owner for final payment. It's a little bit convoluted, but when you're looking at it, what I recommend to my clients is that if the time is not yet available to include the retainage for some reason, but you're coming near the 1-year deadline, go ahead and file your lawsuit. Don't include the retainage, but file your lawsuit, and then you can amend your lawsuit later to include the retainage at the time the statutory condition is met. So with that, I'm going to go ahead and turn it over to my partner, Joby Burr, who's going to talk to you about the Federal Miller Act bonds.
Thanks, Ryan. Welcome, everyone. Like Ryan was talking about with the Florida Little Miller Act, there are a number of similarities between that statute and that covers federal projects. And like on state public projects, contractors, subcontractors, materialmen cannot file or record mechanics liens on those projects because of the doctrine of sovereign immunity. And back in the day, it left unpaid material suppliers and subcontractors on those projects without any sort of protection. So back in 1894, Congress eliminated this issue by enacting the Hurd Act, which then became the Miller Act. And the Miller Act requires that contractors provide a payment and performance bond for specific types of projects. Next slide, please. As I said earlier, it protects certain subcontractors and material suppliers who have not been paid by the general contractor. It's a pretty short statute. I would recommend that you all who are performing work on federal projects review it. It only applies to projects where the land or improvement is actually owned by the federal government and not private or state-owned projects. And this just gives you how it applies. It's for any federal government project that exceeds $100,000. The general contractor is required to furnish the payment and performance bond required by the Miller Act. And typically what we deal with on a more regular basis is the payment bond component of the Miller Act, and whether we're representing the general contractor or a subcontractor, and the claim that a sub may bring against that payment bond, and similarly the defenses that the general contractor has to any claims on that particular bond. We touched upon the difference between payment and performance bonds, but in the earlier slides when Austin was talking, but the performance bond is provided by a surety, and it ensures that the performance is appropriate and protects the government, and it protects the government in the event that the contractor doesn't do the work correctly or doesn't do the work timely, and the surety has to step in and make good on that obligation. Similarly, the payment bond component of it protects people who are doing work out there on a federal project. Not all persons, will get into who's protected and who's not, but it's meant to protect those people supplying labor and material, and it stands in the place of a mechanic's lien, which would be recorded on a private project to ensure payment to those folks. This slide shows you all of the folks that are and are not protected under the federal Miller Act on a payment bond claim. Of course, first-tier subcontractors, those who have privity of contract with the general contractor, are protected. They have Miller right bond claims that they can assert. Second-tier subcontractors, those who have contracted directly with a first-tier subcontractor, have Miller Act payment bond rights. A first-tier material supplier and a second-tier material supplier. However, the payment bond does not protect general contractors or any lower tier subcontractors or material suppliers other than the ones referenced above. So some of you may on this presentation say, well, what rights do general contractors have if they're not paid on the project? Well, they don't have, on a federal public project, they don't have lien rights and they don't have payment bond rights. Their only rights are related to what they can obtain from the owner. Notice requirements. These are a bit different than Ryan's Little Miller Act presentation. There's only a couple things required here to perfect a payment bond claim under the federal Miller Act. You have to wait 90 days after the last of furnishing of materials before bringing a claim if you're one of those first-tier subcontractors or first-tier material men. However, if you're in the second-tier variety, you have to provide a written notice within the 90-day period that has to set out what you're owed, has to be in writing, and the other information here in the slide, name the party to whom the material was furnished and delivered to the general contractor in various ways you can do that. What we typically do is, if we're representing a second-tier subcontractor, we want to make sure that everybody up the chain has a copy of the first notice and only notice that those second-tier subcontractors and material suppliers have to provide. So we certainly would provide it to the general contractor and the surety and anyone else that we can think of to make sure that we're covered under that notice. You may recall under the 255-05 bond presentation that Ryan gave, there was more than one notice requirement to be provided. Here under the Miller Act, there's no notice required if you were one of those first-tier subcontractors or suppliers, but if you were a second-tier subcontractor or supplier, there is one notice that you have to provide during that 90-day period. If you are a subcontractor, first-tier subcontractor, and you haven't been paid within that 90-day period, once that 90 days passes, all you need to do is get your lawsuit filed timely, and we'll get into that in a minute. So what are the requirements once somebody puts the general contractor on notice of the claim? They have a duty to forward the notice of claim to the surety and the bond company. Claimants also has to ensure that the surety has a copy of that notice. Again, best practice here, don't rely on the general contractor if you're a subcontractor or supplier to do the forwarding of the notice. Go ahead and figure out who the surety is. There's usually a couple of addresses. Send the notice to all that you see in some form that assures that you have proof of delivery and receipt of that notice. Lawsuits. Just be aware that you have 1 year from the last day of furnishing labor or materials to bring an action on the payment bond. Again, if you're a first-tier subcontractor or supplier, you can do that on day 91, or you can wait until sometime after that, but within that 1 year period of filing your lawsuit. If you are a second-tier subcontractor or supplier, don't forget that you have to provide that 90-day written, within that 90-day period, that written notice before you file your lawsuit. Otherwise, you'll have a problem if you try to file your lawsuit without providing that prior written notice. These are interesting cases because when the lawsuit is filed by the bond claimant, it's filed in the United States District Court. It has to be filed in federal court, thus the Federal Miller Act, and it has to be brought in the name of the United States for the use and benefit of the person bringing the lawsuit. So it would be United States for the use and benefit of Subcontractor Inc. Would be the name of the plaintiff. And again, it'd have to be filed in the federal district court where the project was performed, regardless of how much is at issue. So these are just a couple, this is just a quick reminder for you all on what you need to do in order to perfect your bond claim. Depending on where you are in the food chain, you may or may not have to give your written notice within that 90-day period. And then you'd have to file, depending on, you just have to make sure you file your lawsuit within that 1 year period, regardless of whether you are a first tier or second tier subcontractor or supplier, and make sure you file it in the right court. Let's talk a little bit about the damages that you can recover as a Federal Miller Act bond claimant. You can get your labor and materials supplied, of course, equipment costs, other types of costs, as well as delay costs. Those sometimes can be very large dollar amounts, so you want to make sure that you've got that as part of your claim. Also prejudgment interest, as long as the contract and state law permits that. Unlike the 255-05 statute and the private payment bond context in Florida, there is no specific provision in the Miller Act that allows for the recovery of attorney's fees, though they may be recoverable if the claimant is entitled to them per the contract. But this particular federal statute is not doesn't speak to the prevailing party's recovery of attorney's fees, so you need to be careful of that when you're looking at whether or not it makes sense to file a lawsuit, because it may not be something that you can recover, and in some of the cases you may spend more money litigating the claim than the claim is actually worth. So something to consider if you're contemplating filing a Miller Act payment bond claim. Bond waivers. These are waivers that general contractors or owners or someone up the food chain will ask a party to sign in exchange for payment. And the main takeaway here is you can't ask someone to waive those rights waive those rights in advance of being paid. So if anyone asks you whether or not, or asks you to provide a payment bond waiver before getting paid, you should let them know that that's contrary to what the statute allows, and you can't do that. Obviously, you don't want to be waiving and releasing claims before you've been paid, but just make sure that any waiver and release is signed, it's in writing, and you read it carefully to make sure that you're only releasing those claims for which you've been paid. We talked a little bit about pay if paid provisions in earlier portions of the presentation. I won't go into the meaning of a pay if paid clause, but keep in mind, just like with the 255.05 presentation, that pay if paid provision in your contract or your subcontract is not going to defeat or delay a subcontractor's recovery under a Miller Act payment bond claim. The whole purpose of the Miller Act and its predecessor, the Hurd Act, was to make sure that certain folks on federal public construction projects are paid, and that's their mechanism to do so. So the policy is you don't want those folks being held up and getting paid for the work that they've done. Subcontractors are going to be able to bring a lawsuit under the Miller Act, regardless of whether the contract provides for some sort of alternative dispute resolution, such as arbitration. You can't prevent a subcontractor or supplier, depending on where you are, from filing that lawsuit in federal court. It has to be filed in federal court. It has to be filed timely. If you don't file it there and you don't file it timely, you won't have a payment bond claim. So no one can prevent the subcontractor or supplier from bringing that claim in federal court. However, what sometimes happens is the subcontract has some sort of alternative dispute resolution between the general contractor and the subcontractor, which oftentimes will result in the Miller Act claim being stayed in federal court while the arbitration or alternative dispute resolution proceeds between the general contractor and the subcontractor on the contractual claims. We also see sometimes where a subcontract includes language providing for a stay in the Miller Act claim pending resolution of claims between the owner and general contractor. We've litigated that situation on a couple of occasions at least, and it's not automatic. There has to be some really solid language in the subcontract that allows the general contractor to stay that Miller Act claim, but that can be done if the wording is correct in the agreement.
All right, well, this has been very informative, and so I want to thank our presenters for that. A couple of questions have come in for the live Q&A here, and if you are interested in submitting a question at this point and you haven't done so yet, feel free to move to the upper right-hand corner of your screen and submit that question. You can even do so anonymously if that works out better for you. But starting with one of the questions that we already have, here's a question. What should you do if you don't know whether or not there is a bond?
I'll take that one, Nikos. Well, so this must apply to a private project because on a public or certainly a federal project, there should be a bond. But my first advice would be check the public records, find the recorded notice of commencement, and if there is a bond, it should be referenced and attached to the notice of commencement. However, sometimes it doesn't happen. It's very rare, but it could happen that the bond's not attached, but there may be a bond. And so how do you find that out? Well, there's a statutory mechanism in 713.23 subsection B that allows you to request, serve a request on the contractor or owner to get a copy of the bond. And actually a best practice of ours is to include that request in your notice to owner form. So the notice to owner form that you use on most of your private projects where it's a construction lien job and not a bond job, you just add that request into the bottom, and it's kind of a safety valve. If the owner or contractor have a bond but it's not recorded and they don't provide it to you in response to that notice to owner request, they are then liable to you for any damages that you suffer for their failure to provide you a copy of the bond.
Thanks, Austin. That was a good answer there. Here's another one with some more time that we have. So on a Florida government project, does a first-tier subcontractor have to serve any type of notice to the surety before bringing a claim?
I'll take this one, Nikos. Yeah, I'm not sure I totally made that clear in my presentation, but yes, if you're the if you have a direct contract with the prime contractor, there's no notice that you have to provide before bringing the lawsuit on the bond. Your only obligation is to timely bring the lawsuit within the 90 days, or I'm sorry, the year of the last date of your final furnishing. That's the only obligation. It's only those subcontractors and suppliers who don't have a contract with the contractor who have to serve the notice to contractor and the notice of non-payment under 255.05.
Got it. Thanks, Ryan. So here's another one. This question says, what do I do if a contractor asks me to waive my Miller Act bond rights in advance?
Nikos, I'll take that one. Short answer, don't do it, and it should be a red flag to anyone on this video. If your general contractor is asking you to do that, it's one thing for them to ask you for a conditional bond waiver, which would be conditioned on payment to you. It's a totally different one to ask you to provide an unconditional bond waiver. It wouldn't be enforceable in my view, even if you did sign it. But I'm not in the business of signing away claims when I haven't been paid. So I would strongly advise you to not do that and turn around and question why the general contractor or whoever it is asking you to sign such a document, because that should raise a red flag for that particular project.
Great, good deal. Thanks, Joby. Well, with no further questions, we will take this moment to adjourn. Want to thank again the presenters for putting this presentation together for everyone today. From the construction industry team at Jimerson Burr, if you've got follow-up questions, feel free to reach out to us. The profiles and the contact information for our presenters is listed simply on our website at jimersonfirm.com. Our phone number is there on your screen. But thanks everyone for joining us, and we'll look